the only way you can overturn an ALJ's decision. The court, you can apply for an Article 78 to bring their decision and get it reviewed by a judge. The only way the judge is going to review it is if it can look back and see if there's a due process, error that was, occurred, and if the facts of the case show something substantial. So if you don't substantiate your arguments, you're going to probably end up losing, like the matter of Canarte.
John, are you going to cover under unlicensed activity finder's fees, or is that separate?
The finder's fees are at the end.
Okay.
Yeah, but I could do it now if you want.
Yeah, do it now, because that's an important one.
All right. Finder's fees. So finder's fees are not permitted to be paid at all. And this is just a blanket statement. You can try to argue with me and figure out how and way, which way. But it really, we get this question a lot. And we've gone over it, to death when we've gone up to the legal conferences. But basically, finder's fees are not permitted to be paid to any person who is not a licensee, licensed under the Department of State, under the real property law. The case law is very clear. If there's a real estate involved, then no person can be paid a commission. So there are certain cases where a majority of the transaction, and these are really big cases. I mean, the ones that I've was able to, look at, it really involves a business transaction, not a real estate transaction. So, you bring, two parties together. There's a finder, a broker, not under the real property law, but a broker or a finder that basically brought two parties together to negotiate a business transaction, the sale of a business. The courts have held if any part of that transaction involves real estate, that person can't get paid a finder's fee. So, but the judge also said it depends on the amount and what the if it's a $20 million deal and the real property element is a $300,000 vacant lot, obviously the finder fee, the law will probably find on the side of that person being able to get a finder's fee because it has nothing to do with the real property. It's very insignificant. Vice versa, you bring the party together and, even if it's a little bit over insignificant, the judge, and you get paid, you can, one, lose the commission altogether, and two. So, there's ways you could probably structure the transaction. All I would say to you is don't even get involved with that. But if it involves real estate at all, the law is very specific. Unless you're licensed under the real property law, you don't get a commission.
Yeah, so I think that the easiest rule of thumb for us to use on this is if somebody is not licensed and they're not a buyer or seller in the transaction, okay, they can't get any money out of it, okay? They can't get any money back from you or anything like that. Now, we do participate in things like Homes for Heroes. You know that there are other brokerages out there like Redfin that give something back to the buyer or seller as part of the transaction that used to show up on the HUD, now it shows up on the CD, okay, that it's a reduction in commission, okay, that is okay. That is okay. A reduction in commission back to the buyer or seller, as long as it's shown on the closing statement, parties in the transaction, is fine. Somebody had come to me once and they wanted to give something back to a seller because they subsequently bought with them, but they didn't do it within the transactions. And I said, no, we can't do it. So that's really the rule of thumb. If you're going to make a concession, you can do it, but it's got to be shown in the closing statement. Okay? Excuse me, what?
On your commission, basically.
Right. So you're reducing the commission of the seller, and the seller is then showing it as a credit to the buyer. That's the real trail of it on the closing statement.
Yeah, that's how we handle it. The brokers will call us and say, John, we want to do it in the contract or whatever. Mm-hmm. We could either work it out ahead of time or work it out prior to the closing, but it gets worked out, and that's a credit. As long as the parties related to the transaction, buyer, seller, and the brokers, that's fine.
But somebody gives you a referral, and they're not licensed, and they want money for that referral, it is not okay.
Right.
Can you give
Yes,
them a gift?
Peter?
What?
What?
No gift. No, not even dinner, not even tickets to the Yankee game. I'm not kidding. I mean, I've seen people lose their license because they got tickets to a Yankee game. So just be
Yes,
careful.
Peter.
Yeah, I believe I know the answer to this, but I want to be clear because I know there's been debate time and again over this. If I, as a licensed agent, help someone in a market center or maybe Keller Williams in West Chester, wherever, and they're just grateful, and they send me a check for $100, even though I'm licensed, I believe I cannot take that check. I believe everything has to come through Rosemary. Is that correct?
I think that is correct.
Yeah, no, they can't come to you directly. You can go to Rosemary and she can pay you. But you can certainly, fee split between agents, but it has to go through the brokerage. It can't be a direct payment to you. Absolutely.
Thank you.
Yes,
And even
Joel?
at the closing, they're all payments.
Just make it clear it's not payable to you.
We don't have a lot of time, and
Yeah.
I'll take it after, but I just want to get this.
Anthony, you have a quick question?
So, can we make a donation, since Rosemary was talking about Homes for Heroes?
Oh, here,
Can
sorry.
we make a donation, a monetary donation to a charity?
I don't see why that would be an issue, Yeah, that's,
So I think actually Anthony and I were discussing this last week. So if an agent got a commission, okay, and an agent themselves personally then wanted to donate to a church, and they wanted to donate it in somebody's name,
I don't see
it's
any.
outside, as far as I'm concerned,
For
it's
me, I don't
outside
see
of
that-
us.
Yeah, it's
We pay the
outside of,
agent.
once you're done, and you want to do something like that, I feel hard pressed that a DOS, I mean, I could see an investigator saying something, but I'm not going to say yes or no because I haven't seen the fact pattern and the law doesn't, go to it at all. So I'm safe to say I think you're okay with it because there's no law that's on the books and I haven't seen DOS decisions and we've seen thousands of them, that where I've seen that fact pattern. The next thing is I want to just touch upon when commissions are due, because obviously this is, an important thing. You want to know, the if, as, and when rule and all of that. And there's fairly recent, 2011 in the legal field is very recent. As you can see, we had 1976 law in Duncan and Hill as being still, the law of New York State. So here, Bowery Partners versus E.G. West 37 involved a seller who included in the listing agreement the common New York language, the commission shall be due and payable only if, as, and when title passes. So those are the trigger words. That's a lot of times, if you don't have that in there, I can tell you that's normally when you have the lawsuit.
That is an M3 exclusion on the MLS form. We all should be using that exclusion on every one of our listings. That's M3.
Okay, and the thing I can tell you is a lot of times when the listing agreement goes to court, it's because the limiting language is not there, and then you have the fight as to when the ready, willing, and able purchaser, and you have to get the facts and circumstances of each case. So here you had the common language. After receiving an offer, the seller demanded that the contract of sale contain no conditions, meaning that all due diligence by the buyer would have to be performed before the contract is executed. The buyer procured a broker that was willing to pay full listing price, $21 million, but would not agree to the no condition demand. Subsequent negotiations broke down, no contract of sale was signed, and the seller refused to pay the broker's commission. Always use the written listing agreement. Okay, that's one of the main points that are brought out in this case. The New York Supreme Court upheld the seller's position. Basically, the law, it's just to confirm the law. If you have this specific language, if title doesn't pass, the commission does not come, is not due. What we should include as real estate agents is also except for a willful default on the part of the seller. Okay, so that'll save you a little bit. If you have that language after the if, as, and when language, and you see that there's intent to, kill a deal, and there's a breach by the seller, there are cases that will hold if you have that willful language in there. But then there's other cases that say the New York law really is New York law. If you have the if, as, and when, unless for egregious, real, clear breach and bad faith on this part of a seller, most courts in New York are not going to hold, that there's a ready, willing, and able, condition to the transaction. Parties should expressly state whether a commission is earned if no closing occurs, because the seller declines to accept a full price offer that conforms to the terms of the listing. If a commission will be owed on these facts, a careful seller will set a high enough listing price as not to be dissatisfied with a price offer. So these are all the, little bit of the, rationale that the court took in deciding this case. If the seller expects to impose unusual terms or conditions in the contract of sale, which might raise a question of whether the seller is acting in good faith, again, that willful default, the broker and seller are well advised to expressly agree in the brokerage agreement that those terms will be part of the contract of sale. So basically, that's really, the extent of that case. New York law is very well settled. There are states that are very broker friendly. So if you have, if you don't have the language, okay, New York leans to the broker. In other states, it goes the other way. If the title doesn't close, I mean, it's really just diametrically 180-degree opposite. New York protects the broker. Other states, there's, the law is, if it doesn't close, they don't get a commission, regardless of this ready, willing, and able, status.
Just regarding any difficulties that you might have with commissions, if you in any way think that you are not going to be paid a commission, or that we will have a problem collecting the commission, the earlier you come to us, the better, okay? The worst thing that happens is when it's on the day of the closing and somebody comes to me and says, this is a problem, and this, and this has happened. Or actually this year we had one, it actually did close. I guess the sheriff had to come. It was a crazy deal, but it was like 2 years later. And the sheriff finally got the seller out of the house. It was a suit for specific performance, and we were able to get a commission. So the earlier you come, the better, because one of the things that John said before that's really important is that New York may be a broker, you may be saying it's in favor of the brokers, but it's very hard for us to collect a commission because there is no lien law, okay? Now, there's this escrow thing that they have, that you have to go to the courthouse. We don't use that, okay? Our legal counsel has advised us, in most cases what we will do is we will send a letter to the seller's attorney saying we are making a claim on the escrow. And you heard what John said before. Once we make a claim on that escrow, they can't release that escrow, okay? So now if we do that and we have enough time to do that before the closing, we are in a much better position. Once that closes and the escrow's gone, we have to litigate. And let me tell you something, I've only litigated once in 20 years, and it was because it was a $50,000, almost a $50,000 commission that was at stake. So it paid for us to litigate. But by the time we finished paying the attorney over $10,000, and the judge is going to make you settle no matter what, because that's what judges in at least Rockland County, that was our experience, do. We ended up with half the commission, less the legal fee. Okay, now, so if it's a normal $10,000 commission, it's not worth it. So we're really out. So the earlier you can come to us with any potential problems, the better off we'll be.
Yeah, you want to preserve your rights. You want to make sure, and you'll get an inkling if there's an issue, ahead of time. The thing with the commission escrow, the commission legislation that was passed, nobody uses it. It really, and not to say, I mean, we've sent letters to sellers' attorneys and they just disregard the letter. They'll pay out the money at the closing, and then what I see is the next thing is when the lawsuit is initiated, that attorney is also named in the lawsuit, breaching a fiduciary responsibility. The problem is sometimes the judges, and what I've seen is the judges, if the seller does release the down payment, the parties to the contract are the only parties that escrow agent, sometimes the court will say, well, he had no duty to the seller's broker or no duty to hold the money other than, so, you know, what would happen in that situation is sometimes you would, and I would suggest you would, you know, we would get in the phone with the buyer's broker or the, you know, the seller's, the buyer's attorney, and have him also send out a letter as well, so that we can basically preserve the right, so that if the judge does decide, you know, that I don't have, you know, legal status to send a letter to tell an escrow agent on a deal, but he's on notice, they're in the contract, I'm comfortable most of the times just sending the letter, and most of the times the attorneys are not going to release the down payment. Unfortunately, I know, because I have an attorney who I'm very close with who actually came into my office and told me, John, we sent the letter and he released the down payment. So, and they named that attorney in the lawsuit. So it happens. Most of the times we're protected that way. The other way with, you know, filing the commission, it just, one big item, and I'm not going to go into it because it's a whole another course, but one big item is that you actually reduce your statute of limitations to collect the commission when you use that route. So, you know, the normal route to sue is a 6-year statute of limitation. If you use the commission escrow, you know, the commission act for realtors, you can reduce that almost to like 6 months. So if you don't act within the 6 months, you actually lose your rights to, you know, enforce your rights. So we don't really recommend it.
I would disagree that New York is a broker favorable
No.
state.
The case law, if you leave the language out and you can prove it, you can win. I mean, most of the cases is when you leave out the if, as, and when. If you have the if, as, and when in there, every case comes down in favor of the seller. Because it really, it's clear. It's if, as, and when title passes, you know. If you add in the except and willful default, you have a shot. You know, you have, but the law itself really is not favorable to the seller. And like I said, it's not part of this course, but if you look at the Real Estate in Depth, the article that I wrote, it really shows you how important a listing agreement is and how important we need to know up front whether a commission is earned or not. Because those 3 cases that I highlighted in next month's article really give you a good idea when, you know, you're going to earn a commission and when a judge is going to say, yeah, that commission was earned. In one of the cases that I have, that I referenced there, it was a father and son. The son didn't give the father the authority to sell the house. All of the facts in that case pointed to the father having a verbal agreement, even though the broker tried to get the father to sign a listing agreement for the property. Never advised the broker that there was that his son also owned the property. What's fun in that case is that the case actually, the law actually says that the broker is not responsible for trying to determine who the owners of the property are. There's no law in the books in New York that require a broker to find out whether he's so if the father who came to this broker said, I represent, you know, I'm the owner, I have total, you know, he didn't even know that the son existed, and the father kind of lied and said that he had a power of attorney for the son, didn't have that either. So what happened was the court found that the broker was entitled to a commission. There was a verbal agreement, and usually it's because there's a verbal agreement, you know, where there's enough facts where they can prove it, determined that the father owed the commission to the brokerage firm in that case. And it's an older case, you know, and then I just bring it up to date with a couple of newer cases. But it's important to know that there, you know, the law is still the law. You know, if they can prove a listing agreement and you brought a ready, willing, and able purchaser, that case goes the next step. They sign contracts. They actually, the father signed on behalf of the son. 2 weeks later, when the attorney found out, I don't know how the attorney didn't know the son was also, no, he misrepresented to the attorney that there was the power of attorney. 2 weeks later, they canceled the contract. I don't know how the buyer's attorney didn't keep their down payment, but in the facts of the case, they canceled it, and they returned the down payment, and the buyer was okay with it. basically on the attorney's rep, the son owns it, he didn't sign it, he probably called him and said, can we just kill this because we can't go forward? And there the court held, the seller did so much to push this to a deal that even though the contract was legally canceled between the two parties, the father still owed a commission. So.
Even though there may not be a law for us to find out who owns the property, okay? We don't want to have to litigate to get a commission over something like that. So we do tell you, you know, you need to be researching and making sure that whoever you're having sign the listing agreement are the actual owners of the property. Same thing with multifamily. You need to be providing a CO, even on rentals, that the property is legal to be rented. Or if it's a multifamily, that there is a CO that exists. The tax record is not good enough, okay? Many tax records say multifamily, and there is no, they may be using it, the tax assessor may have it, but there is no CO on that property, and it's not going to be able to transfer title. So we got to do that CYA on these types of things and make sure that we have the right parties and the right number of units in the property.
Yeah, if you look at my October article, basically my 3 rules of thumb, okay? Every broker should ask for at least, the very least, a deed, prior title report or title policy, and a survey. I mean, those are really, you know, you'll read the article and it goes into, but those are important. You know, one, because, like Rosemary said, tax bills sometimes don't reflect all the owners. There could be 4 owners and it only reflects 2 of them. You know, so you can't go by that. An actual deed, you know who the parties are, and you have to make sure you deal with the right parties. The other 2 cases that I deal with in next month's article is basically divorce couples, okay? Where the courts really, if there's an agreement and there's a divorce couple, you know, a divorce situation involved, you need to get the agreement of both parties when the house is listed. You have to make sure you're up front. Sometimes one broker, you know, one party wants to go with one broker, another party wants to go with another, and sometimes you got to go to court and have the court decide who they're going to use. So.
The divorces are the messiest things. I get more of those across my desk than anything in a year. The other thing that you want to check on divorces is if you have get something in writing ahead of time that says what is going to happen if one party ultimately buys the other one out. Okay, because right now we're in a little squabble because one party decided to buy the other one out, and we had brought a ready, willing, and able buyer for the same amount of money, and now, you know, we're looking for a commission, and they don't want to pay a commission because it's an internal transaction. So, yeah, divorces are messy.
So you just got to be, you know, and really, if you take in clients and you don't know what to do with them, you have a wonderful support staff. So you have to talk it through and figure out if someone else in the, you know, in the firm has dealt with this and how to go about it. But you have to be very clear, because a lot of times, you know, a husband or a wife will, you know, engage a firm and not say anything about it. Sprinkler systems, just to tell you that this was defeated. This was a huge, huge victory for us. It would have cost basically $24,000 for a 15,000 square foot home if this would have passed. So basically, you know, we have to thank NYSAR and the Hudson Gateway, you know, for going up there and lobbying and pushing,
Builders Association.
The Builders Association, absolutely. So, you know, and listen, we're not trying, the point to take away on this is that we're not trying to say it's not a safety issue. It's just more of a burden issue than anything else. We, you know, obviously the arguments were, you know, they brought family members, especially lately, you know, in the past few months we've had a lot of the fires with, you know, some gas explosions in the city and stuff like that. So it wasn't an issue that wasn't really an important issue. It's just to tell the client $24,000 is a lot. I'm just going to go quickly in 3 minutes and finish the rest. Legislative, hold on. Source of income is law in New York State. It's not law in New York State yet. It's there. It's going to happen. We're just waiting for the